if after that he does a job and he does it well, I still feel that the compensation given to him by the court and the job salary that he gets as if he was an able-bodied person, there is no connection.
So you have the disability which he incurs as an employee. We are not talking of that disability. Now, a person is an able-bodied person, but he meets in an accident, there is a disability caused to him, for which he is compensated by the court. Now, in treating him as a person, as a physically challenged person, are we not to take into account that he has received compensation for the disability which he has sustained and to the extent of disability?
Can I
respond? As far as I'm concerned, there's not people who want to answer you. As far as I'm concerned, no.
Can I respond? Sure. I never heard such preposterous principle that if you receive the compensation, then thereafter you should not work. I have never heard of such proposition. This is his right. He has a right to work.
No, nobody is saying that you should not work. But in providing the protection of the act, are we not to take into account the extent of compensation that he has already received?
I don't think, if I may answer this question, I don't think the two issues are related.
You are confusing the two types of disability, one which he has sustained during employment and the other which he has sustained
outside. There is no confusion, and I think the audience is all with me that there is no connection between... Excuse me, please. Ladies and gentlemen, can Anurag Mohit please speak?
You have the disability in mind, the Supreme Court judgment in mind, where the disability was suffered in the course of employment, not outside the court.
I would like to submit one small clarification which may be of any help.
Just one short intervention and then we will
very brief intervention. Before the Disability Act came into force, there was a very pronounced, I would say, evident consideration about the nature and the cause of disability. What is the extent of disability and the cause of disability? But with the enactment of the Act, Disabilities Act, I think those two things have been done away with, because when the Act defines disability, it talks about, for example, blindness, it talks about locomotor impairment, regardless how the blindness has happened, regardless how the locomotor impairment has happened, whether it is an outcome of a hereditary condition or an accident or in reaction to a medicine or a negligence of a doctor in some treatment, none of those withstanding none of those causes, if the person acquires a condition which results in blindness or local impairment, which we can call disability, that would be under the law, under this Act, would be treated as disability, and the person will be entitled to all benefits and entitlements under this Act. So the person is covered regardless when the disability happens and how it happens. That's my understanding.
Does it contemplate a situation where for the disability has been granted compensation?
It is, if the disability is compensated, for example, under the Motor Accident Act, that's a compensation for the disadvantage. There's a compensation for a disadvantage that happens due to that accident. But when I apply for a job or apply to get admission in a college, that has no relation with the compensation I received, because that does not have any direct link to my right of receiving education or my right of entering into work and benefiting from the benefit of reservation meant for persons with disabilities. Two are, I think, not linked at all.
Thank you, Anuradha. And can I request that this discussion can be carried on over the lunch, because we are running against the time. Major General Cardozo has already begun, and it's too late to introduce him, and he's already told us something about the personal history that I intended to talk about. But I think I'll just speak briefly. General Cardozo, he had acquired a disability in action as a soldier. He lost a leg in the Bangladesh operation in 1971. He went on to be the first war-disabled officer to command an infantry brigade. After retirement, he has been actively involved in the disability movement, especially the legal advocacy for disability rights. With the Spastic Society now, it is called ADI, and he is currently the chairperson of the Rehabilitation Council of India, General Cardozo.
Justices, friends, I've been asked to speak to you today about the Rehabilitation Council of India. I think enough has been said about the acts, and I'd like to speak to you today instead, with the permission of the organizers, which I've already taken, for the situation of disability in the country and in the world and in society, and what legislation can do to improve that situation. When I talk about governments, when I talk about politicians, when I talk about the bureaucracy, please take it that I'm talking about such institutions all over the world and not specifically about our own country. There's a lot that one can say about the manner in which society considers persons with disability. I do appreciate that we are running late and everybody wants to go for lunch. But I also think that these are important issues, and what's the point of moving from conference to conference, from discussions to seminars, and doing nothing about it. I've been given a chance to speak to you because I believe that you are in a position to effect change. And therefore, I would like to say what to me is important for persons who are disabled. I don't think lunch is that important. I think the issue here today, what we need to consider, is that governments the world over consider disability as a problem rather than a priority. And if they reverse things around, the whole situation would change. Actually, it is a matter of perception. If a person who is disabled considers himself to be disabled, then he will be really disabled. And if governments consider the disabled to be a problem, then they will continue to be a problem and not a priority. I think this is best illustrated by a couple of stories. You have heard 3 success stories in the morning told by Honorable Justice Shivraj Patil. I'd like to tell you 3 more. This is the story of a young boy. His name is Alexander Firi of Zimbabwe. When he was a young boy, he got hit by a car and he got disabled. He belonged to a very poor family, and his family, his mother and father who had other children, decided that they could not cope with the economic, social problem of bringing up this child. So one night, they took him and dumped him in a hospital. Luckily for him, an NGO saw his plight, took charge of him, educated him. He was a smart boy. He did his studies. He graduated. He became a professional architect. He bought his own car. And then he decided to trace out his family. And he drove down to that remote village and met his parents and his brothers and sisters. His parents were embarrassed because they told the other siblings that Alexander was no more. But here was Alexander in a suit, in a car, driving. Alexander held no animosity towards his parents. On the contrary, he decided to to educate his brothers and sisters. As an architect, he redesigned his village. This person who was considered to be disabled contributed not only to his family, but to his village, to his community, and indirectly to his country. Today in our country, the Census Commission has said that they are 2% is grossly wrong. There are many reasons for this. I don't want to go into the details, but some of them have been covered by Dr. Aloka Guha. One is the social stigma. Families don't want to broadcast the fact that they have a disabled person in the house. Secondly, the enumerators. Firstly, you all need to know that the Census Commission was against counting persons who are disabled. They said, no way, we can't do it. We told them, it's so simple. You knock on the door, all you have to say is घर में कोई विकलांग है या नहीं? अगर है तो देखने में है, सुनने में है, मनगुती में है, बोलने में है या चालने में? And note it down. They said, no, it's too difficult. It took us 7 months on the streets before we could convince the Census Commission that we needed to be counted. By then, it was too late for them to train the enumerators, and they got it all wrong. Our assessment is it is about 7%. That's 70 million people who are disabled in this country. When they came to my house, I asked them, you haven't asked me a question. I said, you have one more question to ask. They said, no. I said, yes, aren't you supposed to ask, is there any disabled person in this house? They said, yes, but you're not disabled. Now, when I'm at home, I wear a slipper on my foot, and on the artificial leg is a shoe. So I said, look down. I am also disabled. So if this is a type of enumeration which was carried on, we have got our figures wrong. If we got our figures wrong, it's a question of numbers. Your planning is wrong, your budgeting is wrong, nothing can move forward, you're moving on wrong data. So coming back to Alexander Philly, what are the lessons that we learn? Firstly, education. The disabled need to get educated. Secondly, he became an architect. The disabled need to be trained. And most important of all, they need to be given an opportunity to study, to work, and to take part in all activities as any normal human being. The second story is an old story, but it doesn't concern people in India, but we hold him as our role model. He is an RAF pilot called Douglas Bader, Victoria Cross. He lost 2 legs in a vehicle accident, and although there was no law to prohibit him from flying, there was no law which said that he could. It is the genius of these people, the RAF of UK, which allowed him to fly. When the air chief came to that aerodrome, Douglas Bader took an aircraft and he picked up that aerodrome, which means he did acrobatics. And the air chief looked up and said, "Who's this madman?" He said, "He's Douglas Bader." "What's he trying to prove?" "That he can fly, sir." He says, "Who's stopping him?" There you are. Douglas Bader went on to become a war ace. He shot down 23 German aircraft, and one day he got shot down over Germany. The newspapers in Germany and the world were full of the fact that Douglas Bader, the air ace, has been captured. When he ejected from his Spitfire, both his legs got caught in the cockpit. He landed on his stumps and he got hurt. They took him to hospital. Germany informed UK, "We've got Douglas Bader." You know, in the army, they never give you one leg. they always give you a leg in reserve. So Douglas Bader had a pair of reserve legs in the UK. So they allowed a Dakota to fly down to Germany. They gave them a corridor and a time, and his legs were dropped over Germany. They gave Douglas Bader his legs. That night, Douglas Bader escaped. How far can you go with 2 wooden legs in snow in Germany? It was winter. They caught hold of Douglas Bader. They took him to the hospital. They took away his legs. They put him on the first floor. What did he do? There were a number of beds over there. He got hold of the bed sheets. He made a rope, tied it to one of the beds, got out of the window from the first floor, and crawled in the snow till he was caught. That is the determination that people who are disabled have to have, and they have it. Can you imagine being blind? Can you imagine the type of world that you live in when you cannot see? Can you imagine being deaf and you cannot hear? And can you imagine being both blind and deaf? And the type of world that you're in? There are such people. I've just visited them in Bombay. And there are such people who communicate. There are such people who work. These boys, when left alone in Bombay and told, go to so-and-so place in Namadari Road, he goes there. He reaches. How does he do it? Don't ask me, I don't know. But people who are disabled have a chip on their shoulder. They want to be given a chance to prove themselves. Are we willing to give them that opportunity? My own case. I shouldn't be talking about myself, but I think it is necessary. I lost a leg in 1971, and I had the story of Douglas Bader in my heart and my mind. And I said to myself, I know less than anybody else with 2 legs. Can I command a battalion, sir? They said, no way, you can't. There is no precedent. There is nobody who's commanded an infantry battalion with a wooden leg. So I thought to myself, what do I need to prove to the army that I'm as good, if not better, than people with 2 legs? I worked hard. I used to get up at 4 in the morning. I used to go for a run. One day, the metal shank, I used to run such a lot, the metal shank securing my leg to my foot snapped. I fell down and my foot was in my boot. I hopped to my boot, picked it up, stood on the road, flagged on a car. He said, do you have a problem? I said, yes. My foot dropped off. So he said, then I explained to him and he gave me a ride home. Just to explain to you that people who are disabled, they try very hard. Anyway, I then went on to do my battle physical efficiency test. The officer in charge said, you will not take part in this test. I said, give me a chance. He said, no. Last year somebody died, you will not take part. I said, no sir, I will take part. He said, I'll put you under arrest. I said, sir, you can put me under arrest after I commit an offence. If you consider this an offence, let me commit the offence and take part, then you put me under arrest. I took part. I left 6 officers behind me in the 2-mile run. Okay, took my case to the vice chief. I was lucky. I was working close to very senior officers. That officer said, come with me to J&K. We went to J&K. To cut a long story short, he was in a chopper and I decided to go climb that picket because my friend was commanding it. I climbed 4,800 feet. He came down in the chopper and he said, how have you reached here? Did you come in a chopper? I said, no sir, I climbed. He said, you can climb? I said, sir, what I cannot do only lies in the minds of my senior officers. He accepted that. The next next day, I went with the chief to Ladakh. I climbed in the snow and the ice. Then the chief came back and wrote on my file, yes, give him a battalion and other war-wounded officers who are not taking shelter of their wounds. Now that's important. Persons who are disabled need to prove themselves. They need to prove that they are as good, if not better, than people who are non-disabled. What happened? I commanded the battalion. When I came up to a brigade, the same bureaucratic system said, there is no precedent. However, to cut a long story short, I commanded the battalion, commanded the brigade, I commanded the division. 4 officers subsequently went up to army commander's rank. That means 1 level below the chief. And one of them became the number 2 in the integrated defense staff, Army, Navy, Air Force. And he was minus both legs. General Joshi. If the army, where the main criteria is physical fitness, can change and give people like us the opportunity, what about the rest of the world? There are lessons here to be learned. You need to give persons who are disabled an opportunity. The perception must change. The attitude must change. I think whenever we are in doubt, we need to go back to the Constitution. What does the Constitution say? I'm not a legal expert. I'm a simple human being. And
legal experts are not human beings.
no, not simple. You're very learned human beings. That's what I meant. You're very learned human beings. I don't know the law as well as you do. But our understanding of the Constitution, it defines good governance as the security and welfare of its people. And if that holds good, there should have been no need for any other legislation to ensure that persons who are disabled can be discriminated against. But that was not so, and therefore these 3 acts came to being. I'm the chairperson of the Rehabilitation Council of India. Basically, just in essence, if you are sick, you go to a doctor. But you go to a doctor who has credentials. He is registered. And therefore, and if that doctor does not do his job well or is committing malpractice, he can be taken to task. Similarly, the RCI Act registers professionals in the field so that they can be monitored and controlled. And then we are also in the business of training persons who are looking after persons who are disabled. The situation today is that we have 28,000 professionals and the requirement is 4 lakhs. By 2016, it will be 6 lakhs. How do we bridge this gap? Face-to-face, distance education, but our job is to ensure quality training. The problem is, how do you combine quality with quantity? That's the problem we are facing. The problem is, if we have got to do all this training, it has to be in the structure of a pyramid. Grassroots level, at a certificate course, diplomas, graduate level, postgraduate level, masters and doctors. But how do we conduct the large number of courses? We are just 40 people in this institution, from me to the Safaiwala. And there are 5 of us who are basically who carry out the problems, who carry out our jobs, the issues of planning and decision making. Therefore, we've got to farm these out to other NGOs, but they need to be monitored. And we need funds. And where are the funds going to come from? Unless the attitude changes and they accept this needs to be done, consider disability as a priority and not a problem. As far as the National Trust Act is concerned, Dr. What's her name? Gua covered it very well, I'm sorry. And as far as the Disabilities Act is concerned, basically it deals with 3 issues: equality of opportunity, protection of rights, equal participation. The Act, I can say a lot about the Act, but there isn't enough time. I'll just concentrate and tell you that in our perception the Act has certain drawbacks. Number one, there is a clause number 71 or is it 72, which says that any person in government service who in good faith takes a decision which is wrong or against the Act, he will not be held liable. So for every step that you take forward, you're taking 2 steps back. You've got to have responsibility and accountability. Number two, as far as the various clauses are concerned, there is no time limit. You will have all public buildings barrier-free. Full stop. When? By when? How many years have passed? 10 years have passed? 15 years have passed. And how long is this going to continue? The MCD, the PWD have not bothered to take cognizance of this. They have not taken all this on board as far as their own rules and regulations are concerned. Why is it that public buildings today, which are still being built, are not barrier-free? So that is as far as that concerns a number of clauses. The third thing is the central government, state governments, local bodies within their economic capacity. What rubbish! 15 years have passed. Why have we not budgeted for it? Something needs to be done about this. Now, as far as the judiciary is concerned, some time ago I was attending a function and I've been abroad and I've seen the way persons with disabled are treated abroad. I have to wind up in 5 minutes. And there was this person from the High Commissioner's office, and I said, Mr. So-and-so, how is it that abroad you've got parking space for persons who are disabled, everybody is in wheelchairs, everybody gets a job, independent living, it's so good abroad. How did you all do it? Now this is where you come in. And he said, sir, we had to shame our governments in doing what they were supposed to do. Okay. If disability is a game, then there are many players. You have the politician, you have the bureaucrat, you have the judiciary, you have the media, you've got NGOs and professionals, disabled themselves, doctors, schools, corporate sector. All have got a part to play. A few months ago, the Australian team trounced the World 11. The World 11 consisted of the best cricketers in the world. Yet in 3 matches, the Australians trounced the World 11, hands down. Why did it happen? Because they did not function as a team. All these players, if we work as a team, we can affect change. We need to work as a team. As far as persons who are disabled are concerned, and as far as the law is concerned, we have something known as graduated response. In that, we first decide when there's an issue to be sorted out, we dialogue. If that doesn't work, then we call such people who are decision makers to seminars and workshops. If that still doesn't work, we go and lobby in Parliament. If that still doesn't work, we go to the media. If still that doesn't work, then we go on dharna. I'm talking about we. I'm sorry. I used to do that before. Now I can't do it. And the last resort is the courts. After that, there's nothing more. You are the final authority to help us out. And I must tell you that as far as persons with disability are concerned, when our cases are put up to the courts correctly, the courts have been very supportive. And we thank you for that. But I have only one thing to say. The Chief Commissioner of Disabilities has got certain authority. But that authority, I heard some people saying that in their courts, whatever the Chief Commissioner or the Commissioner of Disabilities have said, they are considered as binding. I think Anurag Moit, who has been Deputy Commissioner of Disabilities, and I don't agree with that entirely. I'll give you two cases. Okay, one case. 5 minutes left. 1 minute, all right. In the state of Haryana, there are about 6 lakh people who are mentally challenged. They apply to special exchanges for jobs. If they don't get a job within 2 years, they're supposed to get a stipend or an allowance of 200 rupees a month. But they cannot draw that allowance unless they have a disability certificate. And they cannot have a disability certificate unless they have an IQ rating. And they cannot have an IQ rating unless there's a clinical psychologist in the district's hospitals. There are 19 districts and not a single one has a clinical psychologist. So what is the use of all these things that the government provides when they cannot get those, whatever the concessions are? So we went to the Chief Commissioner of Disability, and the Chief Commissioner advised. He or she only has the capacity to advise the government of Haryana. Will you please attend to this problem and have clinical psychologists appointed in your districts? Why is it that the Chief Commissioner of Disability is not given more power? I don't know. Paper said recently that about 1 or 2 million cases pending. There are 2,000 judges' appointments vacant. Then why is it that the Chief Commissioner of Disability is not given more power to sort out problems which he or she is totally conversant with? Something needs to be done. Or, as you said today, that whatever, if it is right, that whatever decisions the Chief Commissioner of Disability or Commissioner of Disability take, you will support it. Something needs to be done, at least for the disabled who are marginalized. I've taken more time than given to me. I thank you for being very patient and listening to me, and I apologize if I exceeded my brief, but I am an activist at heart, and I am speaking from my heart. Thank you so much.
Thank you so much, General Cardozo. May I invite everybody for the lunch, and may I also make an unreasonable request to come back in half an hour, because we have some very, very interesting speakers in the next session. Thank you. Very well today. Justice Sikri practiced in the Delhi High Court for 20 years from 1977 through 1997. In the last 2 years of that period as designated senior counsel, he was a role model for all young lawyers then. He was elevated in 1999 to the Delhi High Court and continued to be an icon as a judge. Several of the disability rights judgments that have been referred to since the morning have been authored by Justice Sikri. He has also been keenly looking at mental health and disability rights issues, and is now looked up to as an ally of the mental disabilities rights movement in the country. May I invite Justice Sikri to deliver his speech.
Good afternoon to you all. It's really a pleasure and rather a matter of honor to be with you here, and I won't say honor to address you, but rather I'll say it's an honor to interact with you on this subject. You have been discussing about disability issues since morning, and as I've seen the program, there was a session on the constitutional framework and then landmark judgments and RCI. I have chosen the subject, or the subject which has been given to me is social context adjudication. with special reference to mental health issues. So I would say, as far as the first part of this topic is concerned, it does not only relate to mental health issues. So when we talk of social context education, so all the issues, social issues with which we are concerned, they come into play. And therefore, in that sense, it may be a continuation of the previous session. Because when I discuss with you about the social context education, I'm not confining it to mental health issues. Of course, after generally discussing social context education, I will then specifically refer to mental health issues as well. Now, what is this social context education? To give you an idea of what my perception is, we as judges, we are supposed to decide cases. We are the adjudicatory authorities. And while deciding these cases, we are supposed to follow law also. So we have to decide these cases within the framework of law. I mean, there is no denial of these facts. We have to ultimately decide the case in accordance with law, and we can't breach the law or go beyond the frontiers of law. Still, when we talk of certain issues or certain types of cases, there is always a discussion that a somewhat different kind of treatment has to be given to these cases. And these are those social issues to which I am referring to, and in that context we call, or we term it as social context adjudication. And these issues may be, which keep coming to us day in and day out. It may be a case of a destitute woman, maybe a case of who is driven by her husband and she is asking for maintenance. It may be a case of a rape victim, and rape victim may be an elderly lady, or she may be a small girl of tender age, 5 years, 10 years of old. It may be a case of Dalits and disabled persons, the two topics with which we are concerned these 2 days. It may be a case of, refugees. So all these issues, when these cases come before us, the perception of the society is, or rather I won't say perception, I'll say expectation of the society is that different treatment has to be given. As I started, and in the beginning I said that we have to decide even whether these are cases involving these issues, or they may be property cases, they may be commercial cases, arbitration. We have to apply law and decide the cases. Then what is that is required specially for deciding such cases that we call social context education? As I have said that, and we know it, the people say that you look here, a different kind of a special treatment is to be given to these cases. Now, these are some of the cases or the issues which I have enumerated. There may be others also. It may be a case of a worker who is dismissed from service and is unemployed. Now, in all these issues, what you will find, a common thread running, is that these may be the cases of special class or deprived class. We talk of equality. Equality is what constitutional mandate is, Article 14. But the question is, and I would say rather there are two facets of this equality. On the one hand, Article 14 itself says, coupled with when we read it along with Article 15 and 16, that there would not be any discrimination on the ground of caste, sex, religion, etc. So therefore, if there is one lady who is coming before you and fighting a case against the husband for alimony or for maintenance, or it's a case of even a rape victim pitched against the person who is accused also has rights under the constitution and under the law, and we don't have to discriminate. But at the same time, other facet is, and which is very important in adjudication, that we know for certainty that in many such cases when they come before us, there is no real equality. I am here talking in terms of, first, I am starting from this, giving a background as to why a different treatment is needed. Equality, I am here referring to equality in terms of fighting powers of the two groups. That is why law mandates or constitution mandates on us to ensure equality. And therefore, it is not ultimately the final decision which we give. I'll come to that also. But what I am emphasizing is, it is not the ultimate decision which is important. Equally important is decision-making process. Right from the date or the stage when the case starts till the time the case concludes and culminates into a judgment. Are we ensuring level playing field for two persons who have come before us? And if we are able to ensure and we are able to create conditions, and then both are on equal footing, and then we decide according to law. And while doing so, what is the treatment which is to be given to the case? And here comes the sensitivity to these issues. And that is what social context adjudication is. So, two aspects I would say. First is decision-making process. And I give a very simple example in this, may not be relating to disability laws. Suppose it's a case where a woman has filed a case under section 125 of the CRPC and she is appearing before a magistrate. Say cases today for argument for fixing of interim maintenance. She has 4 or 5 years old child who goes to school or doesn't go to school. I'll maybe say, take an example, old parent who are not able to maintain her. And today she comes to the court expecting that she may be given some maintenance order today. Say husband is an employed who is in government service. There is no quarrel about how much he is earning. But the lawyers are on strike. Or judge has much more work than what he can handle, because that is the problem in today's date. And therefore this case, for some reason or the other, is not taken up and 4 or 5 months adjournment is granted. Now even after 5 months, if the judge gives that maintenance, she would not be that happy, because she wanted that maintenance today. So was that judge sensitive enough to put himself into the shoes of that lady and see what she wants, and therefore I should not unnecessarily adjourn the case? Legally he also knew that she is entitled to this order. Now this is an obvious example I am giving. When I come to disability and other issues, I'll give specific references. Then what should be the approach of the judges in deciding such cases. So, this is, when we deal with such issues, this is what is required of us, this is expected of us. I know I am talking to all the judges who are much, even most of you are even senior to me, and it's don't take it that I am trying to advise you. Everybody knows what it is. I'm only, this is a task given to me, so I'm only explaining what we are required to do, what people expect from us. Now, in this context, let me deal with first disability issues and thereafter with mental health issues. You have, in the morning session, must have discussed so many judgments. And in the cases relating to disability, now we have the Act of 1995, which gives various rights to the disabled. So when a disabled person comes before the court, and when we talk of social context adjudication, what has to be our approach? Apart from procedural aspects, etc., what I have discussed, which apply to every type of case, and our sensitization about the needs. Now, if we look this from another angle, and ultimately it's the interpretative process, how we interpret the law and give a different hue, different color, and different dimension to the same problem from our different perception, would be the hallmark while deciding such cases. Now, let me point out here that what is expected, first thing which is very necessary in such cases is that all these issues, that we don't have to go by our perceptions, what we think of these disabled persons. And in the process, what we can say is, it is the unlearning of what our perceptions, beliefs, etc. are. Giving you an example of disability issues, suppose, what is the approach we have to adopt in such cases? If we have in our mind that a person suffering from disability, he needs care, he needs medical treatment, it's a medical issue, he needs our sympathies, but when it comes to performing the job, when we have to give the employment, then sorry, we have this feeling he will not be able to do the work which an able-bodied person can do. So the moment we have this kind of perception in our mind, we may not be able to do justice to him. On the other hand, the same issue, if we think it is not only a medical issue, or rather I would use the expression, it is no more a medical issue, it is a human right issue. Any person suffering from any disability is as much part of the society, can also be an asset to the society. If we see the positive side of it, and we have before us the cases, the examples where persons suffering from disabilities have been able to overcome their disabilities and have been able to achieve laurels and milestones in their particular field, our perception of the same case may be totally different. Because I'm not to discuss the cases which you have discussed in the morning, although I don't know how many cases were discussed, but take the case of giving an employment. If I have in my mind a person who is a disabled person, visually disabled or physically handicapped, that there is a 3% reservation given in the employment, a person applies and the employer, after interviewing him, doesn't select. Now, normal law is that it is the employer's prerogative. Fair chance of opportunity is given. He has competed with others, but he could not be selected. What courts can do? Employer is the best judge to find the suitability. Now, if in a same case one goes little deep into it, and I'm saying from experience and certain case law which came before me, where one could find that it was because of the psyche of the employer, that employer did not want such a person, then we can give the mandate and we can decide those very cases. I don't know in the morning whether the case of Shruti Karwa, Delhi University, it was discussed, that was one example. And case, there was another case of a visually handicapped person, again in the University of Delhi, where it was found that some excuses were given although the person was competent to do the job. So it would change the very nature, or it would change the very ideology of the judge or the manner in which the case is to be dealt with. So therefore, what I say here, and I mean limited to as far as social context education is concerned, I may only say there is I'm trying to give all my ideas in limited time which is available with me. Although on this social context education itself and with examples much can be said, but we have to ensure level playing field. We have to ensure procedural equality. We have to be sensitive to social context problems, and in the process, I said we don't have to be influenced by our personal issues, personal beliefs, etc. And ultimately, what is important is, while interpreting these laws, we have to give purposive interpretation which advance the cause for which particular legislation was enacted and which applies to social disability laws as well. And this same thing applies to the mental health issues. Here, as far as mental health issues are concerned, unfortunately, in India, although disability issues, or we call it physical disability issues, the disability rights movement in India has achieved laudable goals, and there's much is said about this, and much is done about it, and there are many NGOs doing commendable work. But its greatest pitfall has been the neglect of the rights of persons with mental disability. What is the difference between the two issues? Issues relating to physical disability and issues relating to mental disability. Now, physical disability issues, as I said, we have to have human right approach. We don't have to have this approach that it is only a medical issue. Same thing applies to some extent to persons suffering from mental illness or mental incapacity also. But while on the one hand, a person suffering from some physical disability, suppose his legs are amputated, we know that he can work on a desk and he can do clerical work. This may not apply to a person suffering from mental incapacity. and therefore it essentially remains a medical issue also. But while dealing with the issues relating to mental illness or persons suffering from mental illness, two aspects are to be kept in mind. This is what I say. Number one is, the law has to provide the option of institutional care subject to the need and informed consent of mental health service users. This is what I have borrowed from the publication of Human Rights Network. Now, this is important. The law has to provide the option of institutional care. I'll come to examples and what are the issues arise out of it. Subject to the need and informed consent of mental health service user, the person who is using the service. And the second is to address the vulnerability of mentally ill and disabled who are constantly exposed to abuse and exploitation in their daily life. Now, coming to the first and treating it as a human right issue also, when we talk of providing medical and institutional care, there are many cases and issues have come up. And first case, which dates back to 1983, was a case of Dr. Upendra Bakshi versus State of UP, where in Agra asylum, inmates were not given proper treatment, etc. And in a PIL, Supreme Court intervened and gave directions for their psychological treatment. So, procedure for admission, procedure for release, and treatment to be followed for mentally ill inmates by state protective homes. So, those were the kind of directions given in that case. Much celebrated case and discussed that case is Sheila Barse. Now, this is again a case where mentally ill persons were put in jail and given inhuman treatment, and Supreme Court came to their rescue, that even the children, those suffering from mental illness, etc., they can't be lodged in jails like this. And then there are cases, there's a case of Veena Sethi, I'll come to that case separately, and Chandan Kumar Panik versus State of West Bengal, where mentally ill persons were put in chains, mentally ill patients in the asylum but chained. Now, here was a human right issue, whether what kind of treatment is to be given to these mentally ill persons and various guidelines.
Will you please give the citation of the case?
Chandan Kumar Panik? Yes, it is. In 1995 supplementary for SCC 505. Sheila Barse, you must have discussed, and you know this is their one is 1986 3 SCC 632, then 1993 4 SCC 204, and then 1995 4 SCC 645. So the three cases of Sheila Barse only, three different at stages which came, and I'm not discussing the case in detail, where committees were appointed which had gone to see the conditions in those asylums and jails, etc., and then remedial measures were suggested. The important issue which arises in our context when we talk of human right issue is the issue of under trial prisoners. Now, there can be two situations. One is a person who is under trial is accused of committing some crime, is a person suffering from mental disability, and it may be defense also of his under section 81, etc. And other is that maybe when the trial is going on, he acquires some mental disability. law is clear, there is no problem about it, that when a person is suffering from mental disability, then he cannot be tried. The further trial has to be stayed. But the question that arises, and from human rights angle, the question which is to be seen is as to what kind of treatment is required in dealing with such cases. If a person is suffering from mental disability, he is lodged in jail, he remains in jail, how he is going to be affected by it, whether his problem is going to become from bad to worse, and what is ultimately to be done with such a case. Suppose this mental illness remains for 10 years, 20 years, 30 years. Whether he has to be incarcerated for all these years. These are the issues which arise. Veena Sethi is the case here which I was discussing it earlier. It is 1982 3 SCC 583, where a person remained in jail for 30 years. No trial could take place because of this reason. And ultimately, when the petition was filed, the court passed the order, Supreme Court ultimately passed the order for his release. And another case which is was decided recently in 2001, that is R.D. Upadhyay versus State of Andhra Pradesh. It is 2001 1 SCC 437, where the person remained in jail for 27 years. Now, similar case, incidentally, I happened to be in the bench in the High Court with Justice D.K. Jain, who is now Chief Justice of Punjab and Haryana High Court. We dealt with this case, and NHRC has played a really important and laudable role in that. Now, this was a case where a person was accused of murder and he had some psychological problem. He would fear, or there would be a sense of fear in him, and he would dread the very sight of a policeman. So what happened when he is arrested, and not naturally in a case which is where he is implicated under 302, bail is also not granted. Maybe at the time when he was arrested,